Welcome to the Goldwater Institute, ladies and gentlemen. As you know, the Goldwater Institute is made possible by the generous support of folks like you, so we thank you for coming. And also, the Goldwater Institute does its good works through many of the things and ideas that you do in your communities to advance the ideas of limited government, individual freedom, and individual responsibility, which is what the Goldwater Institute stands for. And with that said, I just have to emphasize, I am absolutely thrilled to have the opportunity to introduce Clint Bolick, for him to tell you about his new book, which every one of you should buy if there are sufficient numbers remaining. His new book, Death Grip, is, I think, the culmination of what he has been attempting to accomplish under the US Constitution as a litigator for economic liberty for his entire career. His goal has been to take the protection of our right to earn an honest living out of the backwaters of constitutional law and into the forefront of what can actually be enforced and defended in court from outrageous, irrational legislation. And you will find in this book the key to doing so from a principled basis, not relying on arbitrary judicial fiat, but instead relying on the 14th Amendment's guarantee of privileges or immunities. There is a specific provision you'll learn more about from Clint tonight that guarantees your economic liberty that has been ignored and denied, and Clint makes the case in this book as to why and how it should be revived. But I'll leave that discussion to Clint because he tells it like no other can, and let me just emphasize this. Clint is one of the most prolific authors. He is one of the most amazing litigators, and he has been an inspiration to me and has made my career possible. He is literally the shoulders on which all of us in constitutional litigation in the conservative and libertarian movement rest. People like Tim Keller at the Institute for Justice and Paul Avalar, who are in the office, they know this even more than I do. I mean, we owe the love that we have for our career to the accomplishments of a man like Clint. And so when I had this opportunity 15 or 16 years into my practice to introduce him for his book, this is really something that reaches the apex of what I do. And so with that said, I want to introduce you, Clint Bolick, Director of the Center for Constitutional Litigation here at the Goldwater Institute, to talk to you about his latest accomplishment. Thank you.
Thank you so much, Nick, and thanks all of you for being here today. Special thanks to my home, the Goldwater Institute, for hosting this forum, and to the Hoover Institution for publishing the book. I'm especially grateful to two of my colleagues, Diane Cohen and Christina Cohn, who today presented me with beautiful white roses and a really cute balloon that at one time had "It's a Boy" on it, and it now says "It's a Book." And I've often said that writing a book is the closest that a male can come to giving birth, because it is such an agonizing process, but I know from my wife's telling me that it is not quite so painful. I was on a very long conference call earlier today, and it gave me time to tool around on Amazon.com, and I discovered, much to my surprise, that this is actually my 10th book. I had not realized that. I also realized I started adding up. If you wanted to acquire the collected works of Clint Bolick, the first 9 books, and you purchased them used at the lowest possible price and did not have to pay shipping or handling, which I think is where the real cost comes, you could acquire the collected works for $5.66. This is very humbling. Well, I thought because of this being my 10th book, that I would actually reflect on a couple of the lessons that I've learned in writing all of these books, really two. One is that good things come in small packages. I have written all of these books, and I have tried to write long, weighty books. You know, and I read these really thick books that are so consequential, and so I aspire to writing them. And it simply hasn't ever happened. It used to be back in my days at the Institute for Justice that whenever I would write a book, my colleagues would gather when the first book arrived to see if I had finally broken the 200-page barrier. I came the closest with my book Transformation, which came in at 199. And I opened up, I'm like, couldn't I have written like 2 more paragraphs? But it's just so frustrating, especially frustrating. I don't know how many of you read E.J. Montini's column today, but Governor Brewer has just written a book that comes in at 208 pages. The title of her book is longer than some of the books that I have written. The only time that I have ever written a book that has surpassed 200 pages, I actually wrote I have published one fiction novel, which I encourage all of you to read. It's called Nikki's Girl. You can check it out on Amazon.com. And I'm writing this book, total labor of love. I send it to a book agent, and she calls me and says, you know, I really, really loved your book, but it is way too long for a novel. She said, you have to cut 75,000 words out of this thing, which just absolutely killed me. And that one still, even though it's got small print and as many words as you can cram onto a page, is 380 pages. So basically, if I give you something that I've written and it's really long, you know I'm making it all up. That's the lesson there. The other... so this book I have to tell you about in that connection. The Hoover Institution comes up to me and says, we are producing a series of books that are 100 pages long. And we're doing that because we want the people who read them to be able to read them in one long sitting, like on an airplane ride or something like that. And I'm like, you have the right guy for this job. So I signed a contract to write a 100-page book. It comes in a few weeks ago, 90 pages. That includes the endnotes. So those of you who buy it, please read the endnotes too. Go all the way to the end. The other thing I've learned about writing books is that any reaction to a book is better than no reaction. 3 of my books were on civil rights, the issue of civil rights. And early in my career, I really was trying very, very hard to redefine civil rights as they were originally understood here in America, as the rights that we all share as Americans, not special privileges and so forth. So I wrote one book, and it got absolutely no reaction at all. Wrote a second book, absolutely no reaction at all. So I write a third book, and this time I'm like, all right, I am just going to give it a provocative title. This has got to get attention. I'm going to call it The Affirmative Action Fraud. And sure enough, it got a reaction. I woke up one Sunday morning, this was a total shock to me, and I open up the Sunday Washington Post, and I'm going through the book review section, and I see a book that looks familiar, and it's mine. I'm like, the Washington Post has reviewed one of my books. I have arrived. This is fantastic. And then I read the review. Oh my gosh, this has to have been the worst review of any book in the history of mankind. It was just awful. So I went into a total fit of depression over this. I'm like, my career is over. The Washington Post has panned me. I will never be able to write another word and have anyone believe it. I went into work the next day, and one of my colleagues, he said, why are you moping around? And I told him this story, and he said, you completely have it wrong, Clint. He said, before you wrote this book, in the eyes of the left, you were beneath contempt. You have now risen to the level of contempt. And I have remained at that level ever since. So hopefully this book will evoke a similar reaction in some circles. Now, this book is about the true legal love of my life, which is economic liberty. And in most circles, most audiences, I would have to define that term, most likely. But in this room, I think almost everyone understands that economic liberty is basically the right to earn an honest living, free from excessive and arbitrary government intervention. It is one of the rights that we most cherish as Americans, that we most take for granted as Americans. And it is one that unfortunately is not very well protected. Now, I have always had a soft spot for entrepreneurs, and I think that it emanates from my childhood when I was always trying to sell things. I hate hard-boiled eggs, for example. And so every Easter, I would get this Easter basket full of really pretty eggs, and I would instantly try to sell them back to my parents. I sold seeds, I sold greeting cards. There are probably some of you in this room that I've attempted to do that with. And what I discovered about entrepreneurship long before I even knew what the word meant is that it's really hard. It is really hard to sell people things, to make things, to figure out a niche that is unfilled, to market, and to make a success out of it. And so when it is inherently hard, and yet the absolute basis for all of our prosperity, it is even more difficult if you add government bureaucrats to the mix. You know, our government should be about making it possible, enabling people to engage in entrepreneurship, and instead, government at every level stifles entrepreneurship. And oftentimes, probably more often than not, the reason that government does it is because someone who has a vested stake in preventing competition has taken the reins of government and attempted to use them for their own ends. That happens over and over again. Whether it's a union or whether it's a business that wants to keep competitors out of the marketplace. Now, the framers of our Constitution attempted to make sure that this would never happen. And probably most of the people in this room have read the magnificent Federalist No. 10 by James Madison, where he talks about the evils of faction. And that's exactly what he was talking about, was trying to create mechanisms in our Constitution that would prevent special interest groups from capturing government and using it toward their own ends. So we have a whole variety of mechanisms in our Constitution intended to do that. One of the things that's most overlooked about Federalist No. 10 is another insight that Madison had, and that is that there is one level of government that is most likely to engage in activity that will limit the ability of people to operate freely and to compete. And that is the local level of government, because as he pointed out, at the local level, the government is smaller, but so is the number of people who combine together who can control the levers of government. And as a result, my colleagues and I have spent a great deal of our time focusing on fighting barriers to enterprise, not so much at the federal level, but at the state and the local level as well. Now, I mentioned mechanisms in the Constitution designed to prevent the evil of faction, but it really came to a head, and this is really what the book focuses on, following the Civil War. After the Civil War, of course, black slaves were emancipated, but the southern states were absolutely dedicated to preventing them from applying the skills that they had learned as slaves. Many of them went into business, many of them attempted to sell their labor, and they were successful at it, and the southern states were very, very upset about this. So they passed a series of laws called the Black Codes, and these Black Codes were aimed at preventing black citizens from engaging in freedom of contract, owning property, and selling their labor on a free market, opening businesses, and that sort of thing. And the Congress passed a law called the Civil Rights Act of 1866 that was designed to protect all of those rights. But Congress, and what a novel thought this is, Congress realized that it might not have the power to pass that legislation. Could you imagine Congress having such a notion today? And so the framers of the Civil Rights Act of 1866 decided to put this in the Constitution itself, to amend the Constitution, and they did so in the 14th Amendment, and they did so through a specific provision of the 14th Amendment. Now, most of the people in this room, and anyone who knows about the 14th Amendment at all, think usually about two of the protections that are in the 14th Amendment that are very, very famous. They are the Due Process Clause. All of us know about due process. It's a term that flows easily from our lips. And equal protection. So two incredibly important constitutional guarantees. But there is a guarantee in the 14th Amendment that appears before the Equal Protection Clause and before the Due Process Clause. It is the first guarantee of the 14th Amendment, and it is a term that is known to almost no Americans, and it is the Privileges or Immunities Clause. And basically it says, no state shall deny the privileges or immunities of citizens. Now, privileges or immunities, what on earth does that mean? At the time, it was as well known as the term life, liberty, and pursuit of happiness, or life, liberty, and property. It was a commonly used term, but it's a term that has completely disappeared from our lexicon today, so that if one were asked, what does the privileges or immunities guarantee mean, if indeed you even knew that there was such a guarantee, most people would be stumped by that. And there's a reason for that. And that is that the United States Supreme Court, in one of the worst decisions it has ever rendered, just years after the Civil War, completely obliterated the Privileges or Immunities Clause, essentially repealed it by judicial fiat, so that the Privileges or Immunities Clause has been used almost never to strike down a law. Laws are routinely struck down under the Equal Protection Guarantee and the Due Process Guarantee, but under the Privileges or Immunities Clause, there is exactly one case in over 100 years that has used the Privileges or Immunities Clause, and that is because of a case aptly known as the Slaughterhouse cases. And basically what happened after the 14th Amendment was adopted was that in the state of Louisiana, and I know this is going to be very hard for you to believe, so please trust me here. Remember, it's a short book, so I wasn't telling tall tales. Bribery was used to pass a law in Louisiana. I know. It's almost, I know. Just try to take it on faith here with a grain of salt. And basically what happened was a group of butchers went to the Louisiana legislature and said, we want to have an exclusive monopoly for slaughtering cattle. And they passed out shares of stock in their corporation to members of the Louisiana legislature who were very compliant after they did that. And so a monopoly was enacted, and scores of butchers were put out of business. So the butchers who were put out of business went to the United States Supreme Court, and they said, this violates the privileges or immunities of citizens. This is our economic liberty, our freedom of enterprise. And the court, by a 5-4 decision, and I have to say, in those days, 5-4 decisions were totally unheard of. Every now and then someone would dissent, but it was never a 5-4 decision, unlike today, when it's almost never when it isn't a 5-4 decision. But the Supreme Court said that the Privileges or Immunities Clause really didn't add anything to the Constitution. It guaranteed access to ports and to the national capital and things that made the dissenters say, we fought a civil war over this? But essentially it held that no substantive rights were protected against the states by the Privileges or Immunities Clause. And as a result, the clause went into disuse, and as a result, economic liberty was completely unprotected. And the book goes into the history of that. It got even worse during the New Deal when the Supreme Court said, you know, certain rights, like freedom of speech, we're going to protect very robustly. Other rights, they're not so important. And as a result, except for a very brief period of time when economic liberty was protected under the Due Process Clause, there's been virtually no protection for economic liberty in the years since then. And as a result, this is basically what the situation is today. In the country on earth that is most doctrinally committed to economic liberty, to freedom of enterprise, where millions of people have come to our shores to pursue their economic dreams, the right to a welfare check receives far greater legal protection than the right to earn an honest living. If you have a welfare check and the government tries to take it away from you, you can go to the Legal Services Corporation and they will defend you like crazy, and they will tie the government up in knots. But if the government decides it doesn't like your business and it wipes you out, and even if it does it for overtly protectionist reasons, it will be upheld in most instances. Well, when I became a lawyer and I read about this, I thought to myself, this has to change. In fact, it was almost by accident that I even discovered that there was such a thing as the Privileges or Immunities Clause. When you study for the bar, I remember the bar instructor saying, there's only one thing you need to know about the Privileges or Immunities Clause. It is never the right answer to a bar exam question. And that is absolutely true. So I decided very early on in my career that my goal as a lawyer, even before getting into school choice cases and all the other things that my colleagues and I have been involved in, that I wanted to overturn the slaughterhouse cases. Just a very modest little goal. Well, and early in my career, I set out to do this, and I wanted to find a good case that I could litigate to try to restore economic liberty, and not just using the Privileges or Immunities Clause. And in order to overturn slaughterhouse, you have to do it in the US Supreme Court. So you have to get a case up to the Supreme Court, and in order to do that, you've got to argue other theories, and there are other theories that you can argue in these cases. And I found my first case in the pages of the Washington Post Sunday magazine, and I couldn't believe it. It was almost like a divine intervention guiding me to this case. It was the story of a man named Ego Brown. And for those of you who are Ayn Rand fans and have ever read the book Anthem, that name, Ego, is very significant. But Ego Brown was a bureaucrat for the Navy. He had worked for many years, but he always wanted to own his own business. And he discovered a lucrative niche in the thousands of scuffed shoes that pound the pavement of the streets of Washington, D.C. He said, you know, there are no shoe shine stands in this town. You have to go to a hotel or whatever. So he decided to set up a shoe shine stand at the corner of 19th and M. And he's a very flamboyant guy. He dressed himself up in a tuxedo and a straw hat and put together what he called Ego Shine, which was you know, the most brilliant shoe shine that you could possibly get. And before long, business was booming. And what happened was that DC social workers actually discovered Ego, and they started referring homeless people to him. And Ego would give them a shower and a shoe shine stand and a tuxedo and put them to work, lifting themselves up by their own bootstraps. So in DC, and anyone who has ever spent any time there knows all too painfully, no good deed goes unpunished. And before long, a DC police officer showed up with a citation telling Ego Brown that he had to shut down his stand because of an old Jim Crow law that was still on the books that forbade shoe shine stands on public streets. So the article is talking about this, and at the end he says, I hope to meet someone someday that can help me deal with this issue. And I thought to myself, I think that would be me. So at this point, he was shining shoes in a hotel as an employee of the hotel, exactly what he did not want to be doing. But when his stand opened that Monday after that article, I was there getting the best shoe shine of my life and saying I would like to represent him. And he said, I can't afford a lawyer. And I said, it's free. And that sounded like a good deal to him. And so we did sweet litigation together. So I took on this case. This was very early in my career. At that point, I was operating out of a basement office across the street from the Supreme Court. I didn't have a secretary. I didn't have a law clerk. It was just me. And this was my first case, and I just took it on with a tremendous amount of passion. And the hotel where Ego was shining shoes shut down for renovations while after the case was filed, and Ego was out of work. And so we filed for a preliminary injunction. And we said, you've got to enjoin this law. We had almost no law to cite at all. It was just really gas fumes that we were trying to grab onto. But I tried to make an argument that his rights had really been violated and that he was in really bad shape. And on a Friday afternoon, we got the word injunction denied. And I have to tell you, one of the things about doing this kind of work, it is really exciting and fun and tremendous rewards. But if you lose, it really hurts, because you know that the person you were representing is depending on you, and that is you are the only thing that can get that person relief. So if you fail, it's really bad. And we had failed. And I remember a friend of mine telling me, it might not be that bad, Clint. I'm like, how could it not be that bad? So we get the decision on Monday, and it turns out that there are 4 standards for a preliminary injunction, and it turned out that the court ruled in our favor on 3 of the 4. He ruled against us on irremediable damage. Basically, the court said he can get money damages that will take care of it. But the court ruled in our favor on likelihood of success on the merits. And so we went back to court, and in the meantime, Ego Brown's financial situation had worsened. His utilities were cut off in the middle of the winter. A friend of mine, Bob Woodson from the National Center for Neighborhood Enterprise, came up with the idea. He said, let's throw a rent party for Ego Brown. And I'll never forget all of these conservatives standing around, digging into their pockets, pulling out money to help Ego Brown. And we helped him get through the winter. And it also helped that we were up against the District of Columbia. Because, as you can imagine, their lawyers were not the best lawyers that we've ever been up against. And the test that the courts apply in this area is the so-called rational basis test, which requires no rationale and no basis. It's pretty easy for the government to satisfy this test. So the judge is asking the DC lawyer, well, what's the reason for keeping this on the books? You allow fruit stands on the streets and flower stands and food vendors, but not shoe shine stands. She says, I don't have to tell you that. It's like, just humor me, And I'm like, no, as a matter of law, I do not have to give you a reason for this law. And in fact, she was right. Nonetheless, we were lucky that the judge disagreed with that and found, for the first time, a federal court in 50 years found that an economic regulation flunked the 14th Amendment. And that was the prototype case that my colleagues at the Institute for Justice and now here at the Goldwater Institute have been building on ever since. Now, there are some really bright spots on the horizon. First of all, those of us who are toiling to overturn Slaughterhouse, and we can probably count them on the fingers of 2 hands, You know, it has not been a subject of tremendous, tremendous interest on the part of the judiciary, as you can imagine, although both liberal and conservative scholars have been very, very critical of the decision. But in a recent United States Supreme Court case, one that probably everyone in this room is familiar with, the McDonald case, which established that the Second Amendment protects the right of individuals to own and carry guns as against state governments, the argument was raised that the right to gun ownership is protected against the states under the 14th Amendment. And the argument was made that that protection comes from the Privileges or Immunities Clause. Previously, the court had said it was the Due Process Clause that limited the power of the states to violate certain of the Bill of Rights. But in this decision, the Privileges or Immunities Clause was raised. And 4 justices took this very, very seriously and went into the history of the slaughterhouse cases and said, this is a very, very shaky precedent in terms of its historical integrity, but we do not have to go there because the Due Process Clause can be extended to limit state power in this area, so they did not go there. However, during oral argument, Justice Scalia raised the question. He said, if there is a right that is not protected under due process, we will entertain, you know, this issue. And of course, economic liberty is the right that is so protected. I mentioned 4 justices. The 5th justice, Justice Clarence Thomas, hates the slaughterhouse cases. And he wrote the most beautiful dissenting or concurring opinion saying that we need to overturn the slaughterhouse cases. And it just goes on. It's probably longer than my book. It's just an absolute jurisprudential masterpiece. So if we can get a case up there, and we are trying to do just that, hopefully we will get there. The other bright spot on the horizon is this. We don't just have the United States Constitution. When we think of our constitutional rights, we instinctively think of the U.S. Constitution, but our first line of constitutional defense against big government is the state constitution. And our state constitution is a progressive era document. So instinctively you might think, well, you know, kind of hostile to freedom of enterprise. But the progressive framers of our state constitution had a tremendous distrust of government, especially when government was aligned with corporate interests who were seeking to use government to advance their own interests. So our state constitution has provisions that I could only wish were in our national constitution, but they are not. Things like the gift clause, under which we successfully attacked the City North subsidy. Things like the special law clause, the equal privileges and immunities clause, which our courts are free to interpret more broadly than the U.S. Supreme Court has interpreted its. And so here at the Goldwater Institute, we are very focused, not just on vindicating federal constitutional rights, but giving life and meaning to the provisions of our state constitution, which are aimed at protecting individual liberty and preventing special interest litigation. And so far, so good. So where are we today? Well, we have been taking on economic liberty cases in a variety of contexts. I have a tattoo on my typing finger. All right, I now realize just for the first time why it is I write such short books. I type with one finger. Duh! Maybe if I used all 10, they'd be 10 times bigger. But I have this tattoo, much to my beautiful wife's chagrin, because we represented a tattoo studio in Tempe against a violation of their property rights. Just yesterday, we filed a case on behalf of Alan Corwin, who many of you know, and that is fighting for his First Amendment rights to advertise his gun website. We have a case that I am absolutely in love with, and I am so grateful to my my friend and colleague Tim Keller at the Institute for Justice for sending this case in our direction, and that is the case of Cindy Vong. Many of you have probably read about it, but basically Cindy Vong is a licensed nail technician in Gilbert. And she discovered that there is a practice that is very popular in many other countries and in other states in the United States, which she calls spa fish. Now, this is a very unusual practice. My friend Tim has done it, and I think he gave it a thumbs up. Yeah, 2 thumbs up. And you put your feet into a tank of water, and these tiny little fish, they are not piranhas. They are called Gararufa fish. They are tiny little fish with no teeth, and they nibble at your feet. And apparently it is a very therapeutic exercise that leaves your feet in really pristine condition. I don't know whether Tim's can be said of Tim's, but people flocked from states all over the place to come and get this service. It was so successful that Cindy had to hire additional staffers. Well, along one day comes the Board of Cosmetology. And in my career, I have come up against the Board of Cosmetology on numerous cases in numerous states, and it is always the same. This is a board, much like many licensing boards, that is comprised of members of the regulated profession. And guess what? They don't always put health and safety first. They put their own interests first. And so they go to the salon, and Cindy says, "Oh, by the way, I'm gonna be doing this spa fish." And they're like, "What's that?" And she explained it to them, and they said, "We don't understand that, and therefore we are going to shut it down." And that is exactly what the board did. So we filed a lawsuit on behalf of Cindy under both the federal and the state constitution, and we made 2 arguments. One, the Board of Cosmetology does not have regulation over fish. I know this is really a very complex legal argument. If you go to a lake and a fish nibbles on you, the Board of Cosmetology is not going to swoop in, arrest the fish for illegal pedicures or whatever. Nonetheless, that was our first argument. And the second was, if indeed the board has regulation over this activity, then it's unconstitutional, because if there are health and safety issues, and there are not, fish cannot communicate diseases, they can't hurt you, she washes your feet before and after and all of this stuff, changes the water. The proper response is not to prohibit it, it is to regulate it in some reasonable fashion and allow her to go forward, and that is the constitutional issue that we're raising. So we went to trial court, and the trial court judge said, "You know what? You should have sought relief from the Board of Cosmetology." We did not think that that was likely to occur, since they had told her she would be charged with a Class 1 misdemeanor if she kept going. So we thought this was a relatively hostile agency. So we appealed this to the Court of Appeals, and I am happy to say that a week ago, the Court of Appeals unanimously overturned the decision, not on the jurisdiction grounds. They actually ruled that under our state statute, and I have to give the Court of Appeals credit because it is a plausible reading, that this is a form of nail technology. The fish do not use little things, emery boards or anything like that, but what the heck. However, they upheld her right to have a day in court to argue the constitutional issues. So this is the next case that is going to be going forward. We're really, really excited about it. And I'm glad to have an opportunity to really talk to you about this case, because whenever we file these economic liberty cases, whether it's on behalf, as IJ does, of people selling caskets, or on behalf of African hair braiders or whatever, there are always people who email us and say, "Why are you wasting your time on some random weird occupation?" In fact, they always use the same term, and not until the spa fish case has this term really had resonance for me. They say, "Don't you have bigger fish to fry?" I would not want to fry these little Gararufa fish. Maybe on Survivor. But in any event, the answer is no, we don't. This is really important. From little cases, such as a group of butchers challenging a slaughterhouse monopoly in the 1870s, to the case of Ego Brown in the 1980s, these cases have enormous resonance because they determine whether we have a right to freedom of enterprise or whether government officials have complete impunity to regulate our professions, not rationally, but irrationally and excessively. I want to finish by telling you the one part of the aftermath of the Ego Brown case that I think vindicates the point that I have just made about the importance of these cases. After the case was over, I mentioned I was a one-man operation at that time. I didn't have a PR director or anything like that, but this case really captured the fancy of the media. Left, right, it didn't matter, because what the government was doing was just so obviously wrong, and what Ego Brown wanted to do, he wasn't harming anyone, he wasn't asking for preferential treatment, he was asking for the basic right to earn a living that belongs of right to all of us. And much to my shock, ABC World News Tonight chose Ego Brown as its person of the week. And they profiled him, and he was back on the street with his shoe shine stand, you know, trying to cajole people to come over and get their shoes shine and all of this stuff. And they showed the joy on his face that he was able to do what he wanted to do. But I'll never forget Peter Jennings' closing words to that broadcast after he said that Ego Brown had won his case and went back to work. He said, "He's made us all a little bit freer." That is what this is all about, and that is why I am so enormously grateful to each and every one of you who makes this work possible. Thank you so much.
We'll take some questions from the audience now. I have a microphone.
I got you.
As I was listening to your stories, by the way, thanks for bringing us a new school of thought on the manicure, pedicure.
One of my colleagues had what I thought was the best line. She said, "You know, the board's actions are absolutely callous."
On a scale of 1 to 10. Anyway, what underlies some of these things? As I'm listening to you about ego, as I'm listening to you about the cosmetology, what underlies it? On its surface, it's, well, we regulate this, and this seems like it doesn't fit. So in both cases, and talk about underlying things that lead to this.
Well, in some instances, it's just sheer bureaucratic hostility. And probably everyone in this room has encountered it at some point when you've gone in for a building permit or for a permit for anything. And, you know, if too often the attitude of government officials, not all the time by any stretch of the imagination, but too often it is, you have to prove to them, you know, that you've done everything you're right, you've dotted every I and crossed every T, and that it's some sort of privilege to get to just do normal things. And they're just so hostile. And I think in the case of Ego Brown, that was basically it. Someone just got offended that he was doing this. And they found that they had a statute that they were able to use to shut him down. And again, with the DC government, it was especially puzzling because on the one hand, you had social workers sending him recruits, and on the other hand, the police shutting him down. More often, though, Greg, it is the case where the government agency or the legislature has been captured. And you know, just to give you an example, one of many in the cases, two actually, in the cases that IJ has handled. One is we took on the Las Vegas limousine monopoly, and they have always had X number of authorized limousine companies, and the process is so rigged against newcomers. Basically, you have to prove that you will not adversely affect the market and so forth, and the incumbent companies just spend tens of thousands of dollars in lawyers fighting against these entry-level entrepreneurs. Another is, I mentioned the casket cartel, and this is an area that IJ is just very, very deeply involved in, where the funeral home industry has gotten laws passed that say that it's you have to be a licensed funeral home owner in order to sell caskets. And this has gone to court in several states. IJ has a mixed record, which I hope will get the cases up to the U.S. Supreme Court. But one of the courts, I think it's gone to three courts of appeal, or no, 2 courts of appeal so far. One of the courts said protectionism is a legitimate government objective. And just think of the ramifications of that. And that just, you know, in my mind, just can't stand. But it is, protectionism is the principal motivating factor. So, right here.
There you go.
In your pending case in Glendale, I see that that's kind of flipped a little bit into your favor. Because now they don't have a buyer, but they just did a $25 million grant, so to speak, to keep the thing running. Any comments there?
Well, things have flipped in our favor ever since we assigned Nick Dronius to the case. This often happens, I have to say. But the question is with the Glendale Coyotes deal, after the NHL said, we are going to yank this team, we're going to relocate it to Canada, if you guys don't capitulate, and we did not capitulate, and they said, well, heck, we'll keep them here for another year after all. But the city now has agreed to pay another $25 million, and this is a portion of the team's anticipated and all but certain operating losses for the next year. So this is like year 10 or year 11 of constant double-digit million-dollar operating losses. And as you know, we have a public records lawsuit against Glendale that has proven to be very, very difficult getting records out of them. And we have not gotten documents that have shown us what services the NHL is obligated to provide and what payments the team is obligated to provide to the city. And we can't know whether it's a gift clause violation until we see those figures. So that is one of our top priorities in our public records case. This is information, by the way, that the city council members also don't have, despite voting for it. And one of the things that is just amazing, and I'll stop on the Coyotes after this, but one of the council members the other night, and you may have seen this on my Facebook post, Joyce Clark, who switched sides to support the subsidy, she said, yes, I'm gambling with taxpayer money. And I'm pretty sure that's unconstitutional.
What effect are your court cases having on our anti-monopoly laws in the country?
Well, so far so good. I mentioned that we had no cases to cite during the Ego Brown case. Now we've got a whole bunch of cases that the Institute for Justice, Pacific Legal Foundation, and the Goldwater Institute, which are the 3 organizations focused on this, have won. So we are fighting. I think the protection against government-imposed monopolies has increased. It's different in different parts of the country, and that leads me to think that eventually the Supreme Court will take up this issue and hopefully reconsider the slaughterhouse cases. I think that so long as I have a very long career it may well happen during my career. I'm sorry.
I have an unrelated comment, and I'd like you to comment on it. The thing that bugs me is people are talking about our Constitution as either we are constitutionalists, believing in the original Constitution, which I believe in, or what's the other term that they living document
Living Constitution, right.
Is there any lawsuits going through the country right now on trying to define what our Constitution really is?
That's a really good question. And, you know, I like to give credit where credit is due, and I am about to say something very, very good about Barack Obama. And that is that since Barack Obama has been elected, more people have read the Constitution from cover to cover than perhaps any time in American history. And that is just a wonderful thing. It's a shame it took that much to do it. But, you know, I go to Tea Party events, one out in the West Valley, and the head of the Tea Party said, how many of you have read the Constitution from cover to cover in the last 6 months? And there were about 300 people in the room, and almost every hand in the room went up. One thing I would like to admonish you all to do is to read the Arizona Constitution from cover to cover. You will be surprised, pleasantly so in most instances, what's happening there. The answer to the second part of your question is emphatically yes. There are several cases that raise really fundamental issues of constitutional law that are working their way up to the United States Supreme Court. A large percentage of them seem to come from Arizona, which is kind of interesting and kind of cool. But none more than the cases challenging the federal health care law, because they get to the very organic question of the relationship between the individual and the federal government and between the states and the individual government. As you know, we passed a Health Care Freedom Act here in Arizona, invoking our state sovereignty to protect the rights of our citizens more than they are protected by the federal government. And we have a lawsuit here at Goldwater challenging the health care law. And the Obama administration has come in and taken the position that that law, the Health Care Freedom Act, is unconstitutional. So that really gets to it. But this issue of the individual mandate, which is slowly, but actually quickly and surely heading up to the U.S. Supreme Court, I think presents a very fundamental issue of constitutional law. And people often ask what they can do. And reading the Constitution is really important. Supporting groups like the Goldwater Institute is very important. And also praying for the health of at least 5 members of the United States Supreme Court, something I ask you to do every single night. Oops, wherever you go, I shall follow, Todd.
You have a wonderful sense of humor.
Thank you.
And along with that, you are making the law a happy and wonderful profession again, which I think we all appreciate.
That is so sweet.
But I have one more comment, and that is you must be having a heyday with all that's going on in Washington, D.C. right now. I find as a little old lady, I'm afraid to go to sleep at night for fear something will happen while my eyes are closed. Thank you.
Thank you so much. You know, I have my wife to thank when I proposed marriage to her, and she said yes, which blew me away. She did say that she would do so on one condition, and that is that we would spend no longer than 1 more year in Washington, D.C., and then we would move to a place where it never snows. Here we are, almost 11 years in Arizona, and we could not be happier, not the least reason for which is how far we are from Washington, D.C. Over there.
You have made it clear how important these economic liberties are to all of us individuals and the small business person and so forth. But would you comment on the effort of the NLRB to prevent Boeing from building airplanes in South Carolina and forcing it to go back to Washington?
That is a really good question. When Barack Obama spoke to the AFL-CIO Executive Council in August of last year, when it became clear that he would no longer control both houses of Congress, he said, "Don't worry. There are lots of things that I can do for you through executive orders and through the National Labor Relations Board." And basically, what he was unable to accomplish, even in an overwhelmingly Democratic Congress, he is now attempting to accomplish through the NLRB and other regulatory agencies in the federal government. And we really, really have to keep a close eye on this. So many people, I think, are a bit complacent because Republicans won the House of Representatives. This is such a tiny, I'd say it's an important victory, but it is a tiny victory in the larger scheme of things, because whoever controls the White House controls two very important things. The person in the White House controls the agencies that make far more laws and regulations than does the United States Congress, and they control judicial appointments, and that is so absolutely essential. NLRB, exactly as you said, has, because of Boeing's supposed anti-union activities, taken that breathtaking step of telling them they cannot relocate a plant from Washington to South Carolina, which is more friendly to employer interests, which I think is shocking. The NLRB has done something else too. It has filed a lawsuit against the state of Arizona, attempting to upend another protection that we established in our Constitution last year, and that is the Save Our Secret ballot, which is the right of workers to have a secret ballot election in union recognition context. And I'm happy to announce that the Goldwater Institute, which drafted that measure, will intervene in that lawsuit to protect that measure. That is not like one of these close calls that divides red and blue America. It was on the ballot in 4 states last year. It passed in all 4 states with an average of 70.5%. Out of 154 counties, it passed in 153. This is a battle we should be eager to take on, because no matter what happens in the courts, we win in the court of public opinion. One last point. In our healthcare lawsuit, which my colleague Diane Cohen is heading up, we are taking on an agency that will make agencies like the NLRB look like modest little entities. It is called, and I hope for those of you who have not heard of this, you will memorize this, the Independent Payment Advisory Board, also known as IPAB. This is the agency that was established by the federal health care law that to control costs under Medicare, and it has sweeping powers to do so. There are 3 features that make this particular agency unprecedented in American history when you combine the 3 factors, and the scariest agency ever created. First of all, it is subject to virtually no congressional oversight. It is virtually impossible for Congress to upend anything that this agency does. Second of all, its rules are unreviewable by the courts. And third, and best of all, it is unrepealable by future Congresses. This is breathtaking, and our lawsuit, which will go to court here in federal district court here in Arizona this summer, is the only one. We are taking on the individual mandate as well, but we are taking on the constitutionality of this agency that has more power than any of its predecessors. So I appreciate your keeping an eye on the federal agencies.
Clint, I'm sure everyone has heard about the little Cato booklet with the Constitution.
Yes.
Why could not the Goldwater Institute publish a small one about the Arizona Constitution?
That is in our plans to do exactly that, a pocket Constitution. It will be a little thicker in your pocket than the U.S. Constitution, but nonetheless, I think it is absolutely critical for citizens to have at their fingertips a copy of our Arizona Constitution and to cite to it frequently in interactions with government officials.
With Roy.
A quick one, Clint. Are the occupational licensing laws in all of the states subject to being turned over by this slaughterhouse appeal?
Roy, basically what would happen if slaughterhouse were overturned, all of these things would be subject to what I would call rigorous rational basis review, which is there has to be a legitimate government objective, and public health and safety is a legitimate public health, or a legitimate government objective, and it has to be rationally related to that. So just to take the taxi cab monopoly example, you could make sure that the taxi cab driver is insured. You could ensure that the taxi cab driver knows how to operate a car safely, that the car itself is inspected, and that sort of thing. But a rule saying that we will award no taxi cab permits since World War II, which has been the case in many cities, would not meet that test. So it would be really on a case-by-case basis. It would not just wipe out all of these agencies by any stretch of the imagination, but it might it would clip their wings a little bit and just keep them to what they are supposed to be doing, which is protecting public health and safety.
Yes, Michelle Bachmann recently pointed out that the last Congress pre-funded Obamacare by over $100 billion. And while we're all working forward to try and get some control on that, it looks like the agencies and the infrastructure that are being put in place more and more every day, to the point where we may get some judicial relief in the end and find that it doesn't make any difference because they have done all the structural harm and all the structural engineering that's required. Is there any thought given to examining the ways and means in which this thing was pre-funded, the backroom deals that went on? Are any of this stuff cognizable as a matter of injunctive relief on the grounds that irreparable harm is occurring every day? And I will simply make a comment to you in that regard. I have a son who's a resident here in town in medicine, and I get reports every day of the harm being done, the careers being abandoned, the practices that are being wound down and about to close. And if we don't do something sooner, and we don't seem to have a Congress that has been able to defund it.
Yes.
Is there anything that litigation can do to address that?
That's a really good question, and I don't fully know the answer to it. If the law is struck down in its entirety, it may be that that the pre-funding aspects could, in fact, be invalidated, unearthed. But I am not familiar enough with them to know whether that would be the case. I would hope that Congress would take action to get rid of them or to replace them with a market-based system that would get rid of that sort of thing. But I honestly don't know enough about that to know. There were a couple of things that the Congress did that were very smart strategically. For example, you mentioned that Congress has been unable to defund it. And that is in large part attributable to the fact that so much of Obamacare is self-funded, in the sense that instead of appropriations from Congress, there are fees that were put in, including the fee on the individual mandate and that sort of thing, that can't be repealed by one house of Congress like an appropriation can be. So that's why there's been not much success there. The bad thing that they did strategically, which is very good for us, is that many of the provisions, including the individual mandate, are not set to go into effect for a couple more years. And so while some people are getting, developing a vested interest in the program, preserving the program, a lot of people have not. And that, I believe, gives us an opening for judicial injunctions or for congressional action. Once a program, like you see the people's reaction to cutting back on Medicare, we don't yet have that kind of popular support for the federal health care law that we have for that. So I think that's, we're very, very lucky for that. One quick side point. Apart from the action in Congress and in the courts, there is so much we could do here at the state level to keep some of these bad things from happening. We passed the Healthcare Freedom Act. The Brewer administration joined the legal challenge against the federal health care law. We did not set up an exchange under the federal health care law. But Governor Brewer vetoed a couple of bills that would have been really, really helpful. One was the healthcare compact that my colleague Nick Tronius championed, that would have established a constitutional defense against participating in the federal health care law. That is a brilliant idea, and that she vetoed, and I just don't understand why. The other was, and this is so important, because you cannot just fight against something, you've got to fight for something. And Arizona became the first state legislature to authorize interstate purchases of insurance. That is so important to lowering the price of health insurance in this country, and Governor Brewer vetoed it. And that, I just don't understand it. We're going to keep going at those ideas, but just by doing, you've always got to think, you know, it's so much easier to affect state and local policy. So what can we do here? And there are so many things we can do here, but we can't do it if we are thwarted, by someone who's supposed to be on our own team. So I hope you will all try to hold the governor accountable for that.
Clint, we're at 10 minutes to 1. Would you like to take one or two more questions, or
sure?
Should we do one more?
Sure. Smack to the front.
Like to see Michelle Bachmann run for president?
I could not answer that question without risking Goldwater's tax status, and hence I will not. Thank you all so much for being here.
Thank you, Clint. Thank you, everyone, for coming. And we'll see you again in a couple of weeks. We're doing another forum on the abuses of the public employee unions.